You know, it's a story we hear all the time, right? Some homeowner gets into a fight with their powerful Homeowners Association. It always feels like this classic David versus Goliath story, where the rule book is a mile thick and the odds are just stacked against the little guy. But what happens when David has actually read that rule book, maybe even more closely than Goliath? Well, we're going to break down exactly how one homeowner did just that.
And boom, this was the final line from an administrative law judge. Against all odds, the homeowner, a woman named Antoinette McCarthy, she won. The judge found that her HOA had in fact broken its own rules.
So that's the big question, isn't it? How in the world did this happen? This is a story all about the power of paying attention to the details, about how a few specific words can change everything, and how one person's careful reading of the fine print completely flipped the script.
Okay, so where did this all start? Well, like a lot of these disputes, it began with money. A ton of money. The board of the Turkey Townhouse Association decided it was time for a massive, mandatory project to replace the roofs on every single home in the community.
And we're not talking about just a few houses here. The project covered all 122 townhomes in this Sedona, Arizona community. I mean, this was a top-to-bottom overhaul for the entire development's roofs, all at the same time.
And the price tag? Get ready for this. Over $3.3 million. Just a staggering sum of money that was going to have a very direct, very real financial impact on every single person living there.
And that financial impact came in the form of what's called a special assessment, basically a mandatory fee on top of your normal dues. Each homeowner was suddenly on the hook for roughly $20,000. Oh, and it was due within 30 days.
Now, to be fair, the HOA board really believed it was doing everything by the book. Their thinking went like this. The roofs are 40 years old, they're failing, we have to do something. And since the roofs are on individual homes, not common areas, they figured, and their lawyer agreed, that they didn't need to put it to a vote. So they decided on a cost split and just moved forward. But one homeowner, Antoinette McCarthy, she saw something different. Something that everyone else, including the lawyers, seemed to have missed. Her entire challenge hinged on the subtle but absolutely crucial difference between two words. Was this a replacement or was it an alteration? So this is where it all splits. On one side, you have the HOA saying, hey, this is a simple, necessary replacement. Our rules say we can do this without a vote. But on the other side, Ms. McCarthy argued, no, no, no. This is way more than that. This is a project with major alterations and improvements, and according to a different rule, that requires a 66% vote from all of us. And she put it so simply during the hearing. She wasn't fighting about whether the roofs needed to be fixed. She was fighting because she believed the project had been completely mislabeled and that little mistake allowed the board to cut the homeowners out of the decision entirely. And this is the really brilliant part. Ms. McCarthy didn't just show up with an opinion. She built her entire case, piece by piece, using evidence she found inside the HOA's own documents. First, she went right to the source, the CC&Rs, the HOA's own rulebook. She pointed out that the text was super specific. It gave the board a pretty narrow power to paint, repair, replace, and care for roofs. That's it. Nothing about upgrading or redesigning or altering. Next, she pulls out the contractor's roofing assessment. And right there, in their own report, it says a new ventilation system was going to be needed. This was a critical find. So why is that such a big deal? Well, because the original 40-year-old roofs had no ventilation system. Zero. This wasn't replacing an old fan with a new one. It was adding an entirely new system to the buildings. And that, she argued, is the definition of an alteration. And she wasn't done. She found another little gem in that same document. The plan called for adding about 4 inches of new insulation to get a modern thermal value. Again, another major component that just wasn't there before. And the list just kept growing. The project also involved adding that new thermal system, physically raising the big HVAC units on the roofs, extending plumbing lines to make that work, even changing the type of skylights in a way that changed the structure. The whole thing was a redesign. So, one by one, she used their own plans to paint this crystal clear picture for the judge. This wasn't just about new shingles. This was a massive alteration and improvement to the building structure and systems. And that, she said, meant they had to follow a different rule. And here it is, the smoking gun. Straight from Article 8, Section 4 of their own CC&Rs. The rulebook itself said that any alteration or improvement like this must be approved by a 2/3 vote of the members. The exact vote that the board decided to skip.
So, with all of this laid out so clearly, you have to wonder, what did the judge think? Well, this is where we see the real power of digging into that fine print.
You know, in a case like this, the legal standard isn't beyond a reasonable doubt, like you see in crime dramas. It's something called a preponderance of the evidence. All that means is that Ms. McCarthy had to convince the judge that her version of the story was more probably true than not. Just tip the scales, even slightly.
And she did. The judge agreed with her on pretty much everything. He ruled that yes, the project clearly included costly additions and upgrades that went way beyond a simple replacement. And because of that complexity and cost, it absolutely should have been put to a vote. The conclusion was obvious. The association broke its own rules.
So, the final order was simple and direct. The HOA was ordered to follow its own CC&Rs, and as a little bonus, they had to pay Miss McCarthy back her $500 filing fee. A clear, total victory for the homeowner.
So what's the big takeaway from all this? It's really that knowledge is power. Those boring rulebooks aren't just there for the board to enforce against you, they're also there for you to hold the board accountable. By simply reading, understanding, and using the specific words in the documents, a single person was able to do just that.
And that really leaves us with one final thought. Millions of us live in communities with HOAs or co-ops or some kind of governing body. We all have a rulebook. The question this whole case leaves us with is a really simple one. Do you know what yours says?